Thank you, ma'am. Good afternoon, one and all present here. It is my distinct pleasure and honor to be welcoming all of you to the informative and special gathering here. We have the great privilege of hosting a distinguished guest among us, Dr. Avish Chakraborty, sir, Assistant Professor at School of Law, Christ University, Bengaluru. Sir has completed his PhD in the year 2018 from University of North Bengal. He has made significant strides as a research scholar on the area of music piracy in film music industry. For the undergraduate students, he offers elective courses on trademark and copyright law. Additionally, he has been given the task of educating engineering students about business processes and how to register intellectual property in India. Sir has been also active in creating and releasing a newsletter on current intellectual property rights concerns as a coordinator of Intellectual Property Rights Committee. With this introduction in this regard, I request you all to join me in giving a warm and hearty welcome to our beloved guest, Dr. Avish Chakraborty, sir. Welcome, sir. Without further ado, let's begin this exciting journey of learning and discovery. Thank you.
Good afternoon, all of you. Please forgive me for my voice. It's bad. It's taken the form of Jagjit Singh's voice. That it's singing. Don't do that. But yeah, we'll be talking about the issues in respect of the music industry. Uh, the title is the presentation is in front of you. We'll start with the question: how many of you doesn't have a music app in your mobile phones? Does not have a mobile app in your mobile phones? So the thing speaks for itself, right? So uh, our life is incomplete with the consumption of or listening to music, and so the applications which we use to listen to music, uh, those applications get the license or get the permission to use those sound recordings. So the discussion today will be starting with the basics of copyright law because I'm not familiar with your understanding level of the pertinent laws. So I will be starting with the basics, and then we'll come to the drafting part. Okay. So copyright license is required not only in respect of music industry, any form of works which is protected by copyright law. If there is a requirement of use of that work, you need to take a permission. We know that intellectual property rights are considered as negative rights. I hope you understand that. Why you say negative rights? Can anyone tell me why intellectual property rights are negative rights? Or can I say intellectual property rights are rights in rem? Do you understand what do you mean by rights in rem? Rights available against the whole world, right? So how is it different from rights in personam? Rights in personam are based on a specific contract which is available against an individual. Rights in rem are available against the entire world for which you do not need to have a contract. Okay, so intellectual property rights are rights in rem because once you are owner of a particular form of intellectual property, it gives you the right to exclude others from using it. You understand? You have studied the concept of trespass in law of torts. You cannot enter into someone else's property. So the owner of the property has a right to exclude you from entering it, of course, without that person's consent. So the same understanding is there in intellectual property rights, be it copyright or trademark or design. So it is a form of a property right. So that is why if you have created a literary work or you have composed a song, you have produced a cinematograph film, then if you are the lawful owner of that work, you can exclude others from using it. And from that context, the requirement of license comes. That, since you are the owner of the particular work, if someone has to use your work, be it a musical work or sound recording or artistic work, there is a requirement of permission. But the way physical property are licensed and the way intellectual property can be licensed, they are entirely different. As you know, that intellectual property comes under the category of incorporeal property or intangible property. And you must be knowing that from the economics point of view, It has a public goods aspect. What do you mean by public goods aspect? Those goods which are non-rivalrous and non-excludable. For example, if you have a cone of ice cream and you at one point of time only one person can have that ice cream, right, or eat that particular ice cream until unless you're sharing it. I don't generally share. So one point of time you can share, only one person can consume that particular product and you can exclude others from using it. But if you take the example of a book, say if how many 50 of us have a Bear Act with us, all of us can read the Bear or a book at the same time, and the quality or the quantity of the book won't get reduced. So simultaneous consumption of the same good at simultaneously is possible. So that is why protection of intellectual property becomes difficult. Um how many of you are familiar with the word torrents on the Pirate Bay? You can raise hand. We should not, but it was a trick question. We should not use it. That's why most of you didn't raise the hand. So all of us know torrents, even though we do not accept it. I principally do not use it. Yeah, so after marriage, I saw that the application was there in my wife's laptop, and it was a very difficult thing, something which I preach against. It was in a laptop, anyways. But point is, the moment a particular sound recording is there in the internet, how much time does it take to be uploaded in torrents? No time, right? So all of us are familiar about sharing of unauthorized files in Telegram, right? We know that. So I'm telling that those are the examples of unauthorized use, and that's why they are violation of law, and that's why license is required to be used. So today's focus of the discussion is we will understand the background of why we need a copyright licensing agreement and how licensing agreement is different from assignment. Licensing is one way of transferring the rights, and it's a temporary transfer. We all know that. So, with that background, I will be presenting this particular topic. We all are familiar with this particular symbol, right? Which is it's a copyright symbol, right? So many time you're in front of when the cover page or the initial part of the books, you will see this sign and we will see that all rights are reserved. Now, what are those rights we will be talking about today? So, copyright includes both economic rights and moral rights. I think those who are in LLM have already studied Copyright Act and are familiar with it. We'll come to that later. So, as I told you that these copyrights are negative rights, and copyright in music is the exclusive right a creator of a piece of music has to prevent others from using it without his or her permission. So that's why I said it's a negative rights. So if you have created a musical work, no one can use that work without your consent. If you have produced a sound recording, so musical work and sound recording sorry, are not the same thing in the eyes of law. So copyright is an exclusive right. Right. So copyright in music is also the permission of a non-create permission a non-creator of music gets from the creator of music to use it. Now, as I was talking about the use of musical works and sound recordings via applications in our mobile phones or in our computer, we are all familiar with the concept of reels, right? Because our attention span is very less. We don't have the patience to watch a 5 minutes long video. Our patience is 30 seconds. So we all are familiar with that. So the reels which are already there, I mean, TikTok had been a menace for us, right? So I hope you understand it was a social problem. I consider TikTok as a social problem. Different version of TikTok is there. But point is, you'll see that use of the sound recordings are there. So in that case also permission is required. So you said that every use of sound recording, whether in social media websites or any other platforms, a permission is required. So that's why drafting agreements become important. Uh, we go to the basics of copyright protection, regardless of the type of work we're talking about. Copyright protection is automatic and it begins at creation. What do you mean by creation? All that is required for a song to enjoy copyright protection is for it to be original and it should exist in a fixed form, right? So, although intellectual property rights is a type of intangible property, but you see that the protection is available only when it is fixed in a tangible form. We know that ideas are not protected by law of copyright. I hope all of you are familiar with that. Ideas are not protected. So when I use the word fixation, means it should be translated into a permanent form. For example, you're writing a poem, so it should be either written manually or it can be written in electronic form. So if you're talking about protection of song, there are different components of song. So if you're talking about the lyrical part of the song, it should be written it down. If you're talking about the musical work, the composition, it should be expressed in the form of graphical notation. I'll be coming to that. Again, the song should be recorded in a medium which you call it as sound recording. So fixation is important. Fixation is the technical word which you use. So until and unless it is available in a permanent form, protection does not begin. And particular peculiarity with copyright protection is that it is automatic. What do you mean by that? So only the moment you are creating that work, means you are fixing the work into a permanent form, the protection starts regardless of registration. So you see that in case of patent protection, registration is compulsory. In case of design, protection of industrial design, registration is compulsory. In case of trademark, registration is optional, but registration gives you certain benefits. But in case of copyright protection, the concept of registration is entirely voluntary. If you want to register, you will get certain benefits, but even without registration, if there are three requirements which are satisfied, that is originality, fixation, and authorship. If these three things are satisfied, without registration, you will get all the rights regardless of whether you have registered it or not. So, of course, I will not going to talk about originality here much, but you should understand that there are different tastes to find out whether a work is original or not. The present understanding of originality is that if the work you have created is not copied from someone else, and if that particular work is the result of the skill and judgment of your intellect, in that case it would be considered as an original work, right? So of course I will not be focusing much on that. So we must require remember that there are three requirements of copyright protection: originality, fixation, and authorship. And copyright protection is automatic in the sense registration is not uh, necessary. For example, you are taking a photograph. These days we see through our eyes less, through our camera we see more, isn't it? Right. So especially I've seen like people going to Taj Mahal and to watch Qutub Minar. They cannot resist themselves from taking a particular picture where they want to hold the Taj Mahal. Like I don't understand why they do that. It is understandable. You cannot lift the Taj Mahal in one hand, but people do that. So, if you, I am not telling you. I mean, if I go to next time to watch, to visit Taj Mahal, and if I take such picture, that becomes a subject matter of copyright protection, and it would be an original work. Maybe idea is already there, but what copyright protect is expression, right? And the fact is that it is the result of skill and judgment. I mean, only human being can think about such photos, and at least Indians, and it is fixed in a permanent form. So these are the basic requirements of copyright protection. When you say fixed forms, especially in respect of music, it may be written or recorded. Does not have to be professionally done. After internet, the entire aspect of music creation has become much more revolutionized. You don't have to wait for publishers these days, right? Example can be Raghu Dixit. You are very much familiar with the name of Raghu Dixit, right? So he is an independent creator, and with a decent microphone and a camera, anyone can be a creator at the age of the internet, right? It can be a YouTuber. So fixed form means music may be written and recorded in music sheet, that is the graphical notation, in compact disc, cassettes, or any other storage device. Then only the protection starts. So when you talk about copyright in music, there are three aspects of it which you should keep in mind. If you take a song, there are three components of it. You can see that. I thought that would be a good song to talk about here. Happy birthday to you, right? So the copyright of that song has expired recently. I hope you know that. So what I'm talking about in the left image is the lyrical component of the song. That is one of the component of a song. If you see the image in the middle, that is what is known as musical work, right? So we say that for copyright protection, fixation is required. But songs are audible to our ears. How do you fix it? I mean, fix in the permanent form. So that is how a song is described. The tune, the composition is described. This is called as, you can see five parallel lines, and there are certain indications. This is known as musical stub. I hope those who are expert in song music, they will be knowing it. So this is how graphical notation is there in order to understand musical work. And on the right hand side, you will see that there are different forms of sound recording. Initially, we had gramophone records, then we had magnetic tape audio cassette recorders, then we had compact disc, then we got MP3 format. I don't know what is the future, right, with artificial intelligence and all. But what I'm trying to say is that the third component of the song is the medium in which recorded. So in every song, there are three components: the lyrical component of it, the musical work component of it, which is described by way of graphical notation, and the sound recording. Right. So to quote the provisions of law, uh, there are two aspects of a song. Section 2, Clause P of the Copyright Act defines what is a musical work. Now, why I'm talking about this definition? Because when we will deal with how to draft a licensing agreement, you should be familiar with what are the works you are transferring. Are you transferring musical work? Are you transferring sound recording? Are you transferring lyrical component of it? That's why it is important to understand the different components of a song. So, if you refer to the provision of Section 2 Clause P of the Copyright Act, it says that musical work means a work consisting of music and includes any graphical notation of such work. What do you mean by graphical notation? The image in the middle, right? So it includes any graphical notation of such work, but does not include any words. What do you mean by words here? The left image. This is the lyrical part of it. So musical work means only the graphical notation part. It does not talk about the lyrical part and any words or any action intended to be sung, spoken, or performed with the music. Can you guess why there is a reference of any action intended to be sung, spoken, or performed with the music? Because that is protected by way of performers' rights. They are not protected as a copyright. So the singer who is singing the particular song does not get a copyright, they get a performer's right. Copyright is given for lyric as well as sound recording. Now, what do you mean by sound recording? Section 2, Clause XX of the Copyright Act defines it, and I tell my students also this is how uh, my students write answers. If they tell them to define something, so if they, that's how the legislators did. Sound recording is what? Sound recording is a recording of sounds. Now that's how the law is there. So it means a recording of sounds from which such sounds may be produced regardless of the medium or which such recording is made or the method by which the sounds are produced. But there is a logic. I mean, I have a different take on the definition, but there is a reason why the definition of sound recording has been structured in this way. You see that the medium in which we listen music has constantly been shifting. As as told you that before there was, gramophone records. Then we had tape, magnetic tape recorders. I do not know whether you have used that. Uh, During my college days, I used to listen to, you heard about Walkman, Sony Walkman, right? Yeah. So you know what is magnetic tape recorders. Then we had compact disc, right? So you see that modes of recording music, a song has constantly been changing. So that's why it is necessary to have a technology neutral definition. That's why the definition of sound recording is given in this manner. Now, the next concept we need to understand is who is considered to be the author or owner of the copyright in music. Why it is important? Because it is the prerogative of the owner of the copyright to license the particular song. So there are two parties in any license: licensor, licensee. So who is the licensor here? The owner of the copyright. Now we see that in one song there are so many different components. So isn't it obvious that the owners of the different components of the song would be different, right? So that's what I'm trying to explain through this picture. On the left hand side, you see the picture of Javed Akhtar. What is the purpose of referring to Javed Akhtar's picture here? He's a lyricist, right? So he has written the lyrics of a song. So he will be the copyright owner only in respect of the lyrical component of it, not in respect of the musical work. not in respect of the sound recording. That is why I refer to the picture of A. Rahman. He is a composer. So he will be the copyright owner in respect of lyrical work? No. He will be the copyright owner in respect of the musical work, the composition. So when he writes music in this format. Can you see the middle, the picture in the middle? So this is what he gets right in it. Okay. And finally, when you see the emblem of or the logo of Sony Music, whatever we understanding here, Sony Music is a record label. They're the owner of the sound recording. You see that different works are owned by different owners, and every time you need to take permission, have to take permission from multiple authorities for that man, and that's why licensing in copyright becomes extremely complex issue because copyright is known as a bundle of right. One form of intellectual property gives rise to multiple type of rights. We'll come to that later, and each of the rights can be transferred separately. That's why the complexity which is there in respect of drafting copyright licensing agreement is not there in other forms of IP because they do not have multiple layers in single work. So that's why it is necessary to understand who is the author or owner of copyrighted musical work. First of all, you need to understand the definition of author. Section 2, Clause D of the Copyright Act defines author. Uh, I have highlighted two aspects. First, in respect of musical work, sorry. Okay. First, in respect of musical work, and second, in respect of cinematographer sound recording. Why I am defining author? Because the law is the author is the first owner of the copyright. There are certain exceptions. So, if you want to know who is the owner of a particular copyright, you need to go to the definition of author. Now, in relation to musical work, who is the author? The answer is the composer. We just saw the example of A. Rahman, right? So, if you want to license a musical work, you want to get a license of the composition, the sheet music, that is the graphical notation part of it. Whom you have to contact? The composer. But if you want to use the sound recording, right, whom you have to contact? Who is the author? The producer. Of course, you may have a doubt that why it is the not the director but the producer is the copyright owner, but that's a subject matter of separate debate. Uh, in copyright law, it is understood that the person who pays the commission or who pays the remuneration is the copyright owner. That is the presumption of law. You can raise questions about the morality of the argument, that whether it is justified or not, but I'm not going to discuss about it. There are many research done to understand that why director is not considered to be the author of a cinematography or sound recording. But under the existing law, the producer is the author of a cinematography or sound recording. For example, Sony Music or BMG or T Series for that matter. So if you want to use a sound recording in a public place, right, for a commercial purpose, say you are playing the song intend to play a sound recording in a restaurant, in a mall, in an airport, or any other public place, in a commercial space, you need to take license because it's a. But there are certain exemptions. For example, if you're college fest where you play sound recording, you are actually playing sound recording, but you don't have to take permission because that use is exempted. So, other if your use is not exempted, so in an education institution, if there is use of a sound recording for non-commercial purpose, see if I instead of delivering a lecture, I play a Marvel movie which you will be liking very much. So still, I need not take a license for that because it's an education institution. But any other cases, you need to take the permission of the producer. That's why it is important to understand who is an author. Now, after determining when do you get copyright protection, what are the subject matter of copyright protection, who is an author, the next thing it is important to understand is who becomes the owner of the protected material, because the owners are the licensor or the assigner. I hope all of you are with me. Is it too boring or you will not answer rightly to my face? I understand that, but I thought you were getting the context in respect of which I'm talking about. Right. Okay. So the general rule is the author of the work is the first owner of the copyright. Right? So if you have written a book, you are the author. Hence, you are the first owner of the copyright. Now, why I'm telling first owner? because it may be the case that you are transferring the copyright to someone else. Say you are the author, but you don't have the means to publish the book. So what you have to do? You have to transfer the copyright to a publisher, either assignment or license. Similarly, you may have composed the song, but you don't have the means to get the song recorded. So you have to record depend on a record label. So what happens? You give the permission to use your musical work. So that's why they say that the author of the work is the first owner of the copyright. Okay. But there are certain exceptions. There are a lot of exceptions given in section 17. I have selected only two exceptions. First, in the case of a photograph taken or a painting or a portrait drawn or an engraving or a cinematograph film made for valuable consideration at the instance of any person, such person shall, in the absence of any agreement to the contrary, be the first owner of the copyright therein. What do you mean by this? Give an example. Say, in case of a photograph taken, say marriage photography, right? So, in case of marriage photography, the photographer is taking the photograph. So, according to law, who should be the owner of the book? If you go back to the definition of author, say in respect of in relation to a photograph, who is the author? The person taking the photograph. So the photographer should be the copyright owner, but no, that is where the twist in the law. It says that in case of a photograph taken, if it is for a valuable consideration at the instance of any person, so the person whose marriage it is, of course, I do not know whether he will be look back on those photos, but if whatever is the purpose, right? So if he has paid for to the photographer to take those photos, so in that case, that person who pays the valuable consideration becomes the owner of that work. So author is someone else, owner is someone else. Are you understanding that? Not necessarily the author is the owner. The general law is that author is the first owner. But if there is a, this is also known as work for hire. If you're hiring someone and you're paying consideration, so the person who pays the consideration becomes a copyright owner, and that's why you see that there's a use of the word cinematograph film here, and that by that logic, the producer is considered to be the owner of the cinematograph film, and especially in case of sound recording. Also, the law says that in case of a work made in the course of the author's employment under a contract of service or apprenticeship, the employer shall, in the absence of any agreement to the contrary, be the first owner of the copyright area. Say if the composer is working in a company under a contract of service. You understand the difference between contract of service and contract for service? Yes, contract of service is contract of apprenticeship, right? So when you are in the master role of a company, you are in the full term employment of a company, that would be considered as a contract of service. For example, I am in the master role of Christ University. I'm a full time faculty of Christ University, so I'm working as a contract of service under a contract of service. In that case, my employer gets all the copyright for all those works which I have created during the course of employment. So the question paper I'm drafting for my students, if it is in relation to the examinations that is conducted by Christ University, the university gets the copyright in respect of those questions. If I am undertaking a research project, even I am the author of the project, but if the project is sponsored by the university becomes the owner of it. Simply, similarly, if there is a composer who is working under a contract of service, even the composer is the author, but the employer will be the copyright owner. You understanding what I'm telling? So, for basic, because you need to understand from whom you should get license. So that is why not always author is not the owner. So you have to find out who is the owner. Most of the cases, the thumb rule is that the author of the work is the first owner. But there are certain exceptions where the owner is different, the author is different. Are you understanding that? Okay. Now, before we go to the next part of the discussion, we should understand that uh, In the life cycle of a musical work as an intellectual property, there are four major stages, and that's where the concept of license also comes. First of all, you need to create an intellectual property, isn't it? Right? You have an idea of a musical work, or I have an idea of a novel or a poem. So until and unless you are fixing it in a permanent form, can you get copyright protection over it? So we talked about originality and fixation and authorship as a requirement. So creation is the first stage of in the life cycle of a musical work. The next stage is protection of the work. You have already written a I mean, composed the musical work. You have already written a poem. So the next stage is protection of that work. Now, after that, the third stage is known as the commercial use, and that's where license comes into picture. Now you have created an intellectual property or musical work in this case. You have obtained IP protection of the work which you have created. In case of copyright, obtaining protection is very easy. It is automatic. It is voluntary. It is not even registration is not compulsory. Now, after you have created the work, the next stage is you will be putting that work in commercial use. That is where transfer of copyright becomes important. And whenever you're transferring a copyright, you have to follow the rules relating to drafting of contract. We'll come to that part. But after commercial use, the last stage which I mentioned here is enforcement of rights. Why? If someone is using your work without your permission, you should be in a position to stop that person from unauthorizedly using your work. So enforcement of rights is also important. That's the litigation part, which we'll be not talking about. We will be only talking about the commercial use part and the drafting part in that context. Before going to what are the different modes of transfer of copyright, first of all, we should know what are the rights which we can be transferring. You understanding what I'm telling? So we till now what we have talked about. What do you mean by copyright in the different works? Who are the authors and owners of the work? So the next stage we have to understand is what right does the copyright owner has, right? There are two types of rights which are provided under Copyright Act. If you are having a bare act, please refer to Section 14 of the Copyright Act. You can refer to the soft copy if usage of mobile is allowed. That is a thing which is forbidden in our university and in lectures. So, but if it is allowed here, you can refer to that. If you refer to Copyright Act of 1957, Section 14 contains a detailed list of different rights. They are known as economic rights, and there is a provision that is Section 57, which talks about protection of moral rights. Does anyone here know the difference between economic rights and moral rights? Hmm? The LLM students must be knowing. Yeah, it's okay if you can explain in your own way. I just want to understand how much you already know.
Moral rights is what it's reflection of his personality.
Very. Yeah.
Economic rights is what he does for his commercial purpose. Right?
Yeah. In a way, yes. In a way, yes. But what are the moral rights that are recognized under the Act? There are two moral rights which are recognized under the Act, under Section 57. Now, why I'm telling this, I'm trying to explain the difference between economic rights and moral rights, is economic rights are transferable, moral rights are non-transferable. Even if you draft an agreement, you say that the author is telling that I'm transferring my moral rights, that agreement will be null and void. At least the provision which says that you're transferring or you're waiving your moral rights, that will be null and void. While studying Constitution, dealing with Article 21 of the Constitution of India, you must have seen that right to life cannot be waived, and that's why suicide is an offense under Indian Penal Code. So there is even certain fundamental rights, even if the individual or the citizens of the country want to waive, they are non-waivable. Similarly, if you look into the rights which are conferred on a copyright owner, there are certain rights which can be transferred by way of entering into an agreement or a contract. But there are certain rights which are not transferable. We'll come to details, but there are two moral rights which are recognized under the Act. That's Section 57 of the Copyright Act. The first moral right is the right to be recognized as the author of the work, right? So, which is also known as the attribution right. So, you have composed a musical work, right? You have sold the copyright to someone else, to X. Now, after X has purchased the copyright, what X has purchased is the economic rights. Okay, and tomorrow the new owner of the copyright in the musical work wants to change the name of the actual author of it. Can it be done? No. I'll give another example. You have written a research paper, you got it published, you have sent it to Oxford University Press for publication. So while publishing the paper, you have signed a copyright declaration form by respect of which you transferred your economic rights to Oxford University Press. Now, a week later, you saw in their website that your article is there, but your article is there, but name of the author has been changed. So you went to the office of Oxford University Publisher and said that why my name is not there. So Oxford University says that I am now the copyright owner of your paper, so I can decide who will be the owner of the who is the author of the work. There is a restriction in law that cannot be done. So even if the author you have transferred the economic rights, the right to be recognized as the author of the work is still there. So that is why in any transfer agreement, be it assignment or license, moral rights is something which cannot be transferred. The rights which are subject to a licensing agreement or an assignment agreement are economic rights. I hope the distinction is clear to you. One more distinction I can highlight here is economic rights are given to the owners of the copyright, but moral rights are given only to the authors of the copyright. You understanding the difference? So we told you that authors are not always the owners, right? So you have written a book, written a novel, you transferred the right to publish it to Cambridge University Press. So in that case, who is the author? The person who wrote the book. Who is the owner of the copyright? The publishing house. Now, just as a matter of reference, if I look into this manual may not be a right example here. This book does not have a copyright notice, but a textbook, if you refer to any novel for that matter, you will see a copyright sign there. When we saw this particular expression, just a second. All rights reserved. So when we see this all concept of all rights reserved, what we are referring to is economic rights, okay, as well as moral rights. When you are transferring, what you are transferring is economic rights and not moral rights. Okay. Now continuing with the discussion. So first of all, we'll try to understand what are the economic rights. Economic rights are rights which the copyright owner can use for commercial benefit. What are the economic rights? For the first economic right is reproduction rights. So if you take the word copyright and you divide it into two parts, what are the two words you are getting? Copy and right. So it means that the owner of the work has the right to make a copy of it. So the most basic or the fundamental rights which a copyright owner gets is the reproduction rights. The copyright owner has the right to prevent others from making copies of his or her music. Now, I hope you will be able to relate why I say that intellectual property rights are rights in rem. They are a right available against the whole world. This is the reason. Right, reproduction right is the most first and most important rights which the copyright owners get. So whatever type of works you are creating, be it an artistic work, a sound recording, or a musical work, a dramatic work, or an artistic work, the first right you get is to prevent others from copying, and this is the reason why licensing agreements are required. You understanding the rationale of having a licensing agreement? Because without this licensing agreement, the use of that work would be an infringement of the copyright. Moving on, right? So distribution right. So I have time till 4 o'clock, right, ma'am? 4:30. Okay.
One question with respect to the musical rights.
Sorry.
Musical music rights.
Copies of his or her music. When I say music, I am referring to the graphical notation. as well as the sound recording separately.
With respect to the sound recording, in rural areas, so many of the people they are using the original that music,
Hmm.
but regional language they are
Yes, sir.
adding it.
I'll come to that part little later when there are variation of songs, there are remixes, there are cover versions. So even for cover versions of instances we're telling, there is a requirement of taking license under that. I'll come to that particular part.
Yes.
Okay, so after reproduction right, the next economic, second important economic right is the distribution rights. That is the rights of the copyright owner to control the distribution of music. All these logos sounds very familiar to you, right? They are known to all of you. So that is why, because there is a copyright protection required. You will see that the same song is available in Amazon Prime Music. The same song will be available in other platforms, in maybe Ghana, in Wink Music, in iTunes, in Spotify. So these are examples of non-exclusive license, right? Which is a most favorite song now. Although, yeah, I mean, current songs it's difficult to listen to me, but anyways, I'll not take an example. I'm not that old, by the way, but still, like current songs is very difficult to listen. But anyway, so you see that the most popular songs they're available in multiple platforms. So that is where the distribution rights are concerned. So as a record label owner, I can decide that the same sound recording can be given license to a multiple, online platforms. So that is why the distribution right is one of the economic rights. I can give Spotify a limited license to use that sound recording. I can give Wink Music the right to use it. So it depends on the different mediums. So second is the distribution right. Next is recording rights. This covers the right to make a sound recording or a video recording of a song, right? That also requires license. I'll go a little fast here. Yeah, right of translation, of course, although not relevant in respect of musical work or sound recording, may be available in respect of literary work. The right to translate or authorize the translation of a piece of music, which is solely that of the creator of the work. I hope those who can read Hindi can find Harry Potter and the Sorcerer's Stone. The philosophy, I cannot read it properly, but I can read the Hindi part of it. Harry Potter or Maut Ka, what is that? Tohaf, right? So that is a translation. So if you're translating it into another language, we are very good in this, right? So that is also a type of economic rights. So translation of a work from one language to another language also requires permission because it's one of the economic rights. So you can see in I think it's a Korean language. My wife can tell I don't understand it is because of Korean drama and all it's in this thing. So this again is a Russian. You can see on the right. So it's translated in Russian. So translation of one language to another language also requires a copyright license or a permission. Yeah, this is what is contextual in the present discussion. The next important economic rights. So, by the way, all these rights are provided under which provision? All these economic rights are enumerated in which provisions of the Copyright Act? Section 14. Section 14 of 14 of the Copyright Act. So the next important economic right is the broadcast and communication to the public. This I'll come in little details later. But the owner of the copyright has the right to control the broadcast of his music on radio, television, and other cable stations. She also has the exclusive right to control the communication of his or her music to the public by means of a loudspeaker or similar devices as seen in shopping malls, banking, halls, clubs, bus, aircraft, restaurants. So any commercial place, if a sound recording is played, that is understood as a communication of the work to the public. You understanding that? There is a discussion that whether broadcast and communication to the public is same. Communication to the public is a generic right. Broadcast is a specific right. Internet casting is a specific right, just like broadcasting, right? So, communication to the public means wireless communication. We all know how, no, not recently, but we have seen that how earlier used to have cable television service with us. So what used to happen? That was a service which was based on wire. There has to be a wire which is connected to your television. But when today you watch the same content via your laptop, via your mobile, right? That is a wireless. Diffusion. There's a wireless providing of service. So that is what is communication to the public. Say you are making copies of this book and selling it to anyone in the market. That is distribution rate. But if you are converting the book into a soft copy or an e-book and you are uploading it to the internet and mailing it to someone, that becomes communication of the work to the public. You understood the difference? Distribution right is distribution by way of physical copies. Communication of the work is otherwise done by physical copies. Are you understanding the difference? So that's why broadcasting comes under the category of communication of the work to the public. You understanding what I'm saying? So that is one of the economic rights here. This is what I was talking about. Moral rights ensure that. So that's what my students also do. So with some textbooks in their classes, right? So they are very creative, very creative. So moral rights ensure that the creator of music is recognized when his work is used or reproduced. It also ensures that a piece of music is not modified in any way that may be derogatory to the reputation. So I was talking about two moral rights. The first one was the right to be recognized as the author of the work. The second right is known as integrity right. Means no one can distort, modify, or mutilate your work in such a manner that it is prejudicial to the honor or reputation of the author. Now, in this age of remix, this question of moral rights become very important. I do not know whether we'll be able to relate this. I come from West Bengal. I'm a Bengali, so all of you know that how we worship Rabindranath Tagore, right? So my mother is a trained Rabindra Sangeet speaker. She has learned. So now the copyright in the songs have expired now. Entire copyright of all works has expired. And now you should see how the songs are mutilated according to my mother's description, because they use all form of violent form of music to the songs composed by Rabindranath Tagore. But in that case, since the copyright has expired, moral rights cannot be brought here because it's given to author. What I'm trying to, that may be a silly example to give. What I'm trying to say here is, if you are distorting a work in such a manner that it is causing injury to the reputation of the author, that's a violation of moral rights. You understanding what I'm trying to say here? There was one case, any students of copyright will be aware of that. The case of Amarnath Sehgal versus Union of India. It was a famous sculpture. So he was responsible for preparing a bronze mural, which was kept at the entrance of the Vigyan Bhavan in New Delhi. So what happened for the renovation of the building? They kept it in the storeroom. Actually, they dumped it in the storeroom, but it was a very polite word. They kept it in the storeroom. After the renovation was not, after renovation was done, it was not restored. The mural was not restored, and it was kept in a very bad shape. So Amarnath Sehgal requested Government of India, because it was commissioned by Government of India, so they were the copyright owner. Now they did not restore it. Government, why they should be bothered about a bronze mural, right? They had other things to do. But Amarnath Sehgal went to the court and said that even though I'm not the owner of the work, the bronze mural, but I am the author of the work, and by virtue of Section 57, I still retain the integrity right. So, by way of the mutilation or modification of the work, my honor has been, my reputation has been injured here. So that's why, and he was successful in claiming compensation from the government at that particular case. What I'm trying to say here is that in any transfer agreement, moral rights should not be there. As a creator, also, you need to be very careful about it. Say you are a creator, uh, and say you have composed a musical work or whatever be the case, and you're transferring the right to someone else, and you're the other side of the user of the work is telling that you should also say that you are waiving your moral rights and you will never claim your moral rights. You should never agree to that. Even if you agree to that, later on that provision in the agreement will be not enforceable because it is subject to protect the reputation. Now we will come to the transfer of copyright. As I told you that if we look into the life cycle of a musical work as an intellectual property, what are the different stages I talked about? What was the first stage? First stage is creation. The second stage was obtaining protection. The third stage was commercialization or commercial use of it. That is where transfer of copyright comes into picture. But licensing agreement is one of the modes of transfer of copyright. So copyright ownership can be transferred, and this must be done by a written agreement. So when I say copyright ownership can be transferred, what right I am talking about? Moral rights or economic rights? When I say that copyright ownership can be transferred, I can transfer only economic rights. Moral rights cannot be transferred. What I'm referring to when I'm talking about economic rights? Reproduction rights means right to make a copy of it, right to distribute the copies of the work, right to translate, right to broadcast that work, right to communicate the work to the public. So these are the rights which can be transferred. That's what I mentioned. That to transfer, whatever it is, assignment or licensing, it only affects the economic rights. Moral rights are not subject to transfer. Right. So just certain basic understanding in respect of transfer of copyright. Since copyright ownership gives a bundle of rights, so you understood what you mean by bundle of right? Just let me give an example. You have written a novel. You have the right to publish it in a paperback edition. You have the right to publish it in a hardbound edition. You have the right to authorize someone to make a movie on the base of the novel. You have a right to authorize someone to compose a musical work based on that particular work. So you see that same novel, you are getting multiple rights. That's why it is known as copyright is bundles of rights. And it is your prerogative, means the owner's prerogative to decide which right to transfer, which right not to transfer. So if I say I have A, B, C, and D rights, say reproduction right, distribution right, broadcasting right, and communication right, only because I have transferred the broadcasting right does not mean I have automatically transferred the reproduction rights. Those three rights are still remaining with me. And that details have to be mentioned in the agreement very clearly. Otherwise, there will be a dispute. I'll come to that later. So copyright ownership talks about bundle of rights, and that's why you give the right to the owner to deal with it. For an example, say if you have authored a novel, you can publish it as a volume or serially in newspaper or magazine. You can give it a license for translation or filming or dramatization. Uh, so in that sense, copyright is a form of investment. We generally, when we talk about investment, we talk about tangible property, we talk about physical property. But even copyright can be used as a form of investment. Why? Because it can be used as a security for loan or other financial transactions. So you understand the concept of mortgage. So your copyright certificate is as good as your title deed of any physical property. So it can be used as a security for loan or other financial transaction. I hope you understand the difference between assignment and license. This is very crucial for a student of copyright because assignment is an actual transfer of copyright ownership from assigner to assignee, whereas license is a limited permit which the licensee have to use the copyright for a given period of time. I hope you understand the difference between sale and lease. The same distinction is there between assignment and license. One interesting thing to observe here is that the Copyright Act does not use the word sell. If you are using mobile, I hope you're using it for Copyright Act only. Anyways, if you can check the entire Copyright Act of 1957, can you find the use of the word sell anywhere in the Act? No. Definitely the answer is no. Because, but why do you find the word sell? You find it in Transfer of Property Act. You find what is that? Sale of Goods Act. Right. So see that is why. In case, have you ever thought what is the difference? What is the reason? Can you why the word sell is not used? Because when you are using the word sell, it means complete ownership is transferred. Right? There cannot be any other rights attached to it. For example, if you're selling your car, sale of a car, So in that case, after the sale, can you say that I have emotional attachment with the car? Once in a month, I will come and take a ride for that car. Can you say that? No. But you see that in case of copyright, moral rights are actually not transferred. It's still with the author. If you are injuring the reputation of the author by distorting and mutilation it, he will drag you to the court, even though you are the copyright owner. That is the reason the word sale is not used in Copyright Act. You're assigning the rights. So when I assign my copyright, it doesn't mean the pages and the binding of the book. What I'm transferring is the rights associated in respect of the book. Means you cannot make a copy of my book without my consent. Are you understanding the difference? In case of assignment, what you're transferring is right, not the physical object. So license is also transfer of a property, but it is for a limited time. License is helpful where you are not sure about the success of your property until and unless you are Himesh Reshammiya. Then it's a different case. I mean, no offense to Himesh Reshammiya, but I don't know whether that can be considered as a music, but yes, he is considered as a musician in India and in the world as well. So, what I mean, I'm sorry if there is a fan of Himesh Reshammiya here, but what I'm trying to say here that when you're giving a permission for a limited time to use a copyright protected work, then it is license. Assignment is permanent, right? License is temporary. Copyright may be assigned by the prospective owner in future work, but the assignment will be effective when the work comes into existence. I hope you understand that. Say you have agreed that you will compose the musical work or for the next song or for the next movie. So it is a future assignment. So the assignment will only take place when you have actually composed the musical work. So, but assignment is possible in respect of future work as well. Now, when we refer to the Copyright Act, I'll come to the statutory provision later. This transfer can be total or it can be partial as well. What do you mean by total or partial transfer? We say that copyright is a bundle of rights. In one work, there can be multiple rights associated with it. So, if I agree to transfer all the economic rights at one time, then it would be total transfer. But if I say I have agreed to transfer two rights, distribution rights and reproduction rights, but I have not decided to transfer the translation rights or broadcasting rights, in that case, it can be partial. So, it is totally the prerogative of the owner of the copyright that whether it should be a complete transfer or whether it should be a partial transfer. And it is important to document it properly in the licensing agreement. I mean, if you're not documenting it properly, good for lawyers because they will ultimately go to the court and the lawyers will be fortunate enough. But it is difficult for the creators, for the actual users, because the value of copyright is momentary. It is for a limited duration. And if you will end up in court, that you should not say that standing in a law college, but we all know the reality. So, problem is if the terms and conditions of the agreement is not clear, that will lead to ambiguity and that will lead to dispute. So, if you think that you are not agreeable to transfer all the rights, that has to be mentioned specifically either in the assignment agreement or the license agreement. Are you understanding what I'm telling? So, since the law allows you to transfer it totally or partially, that has to be documented. In partial assignment, a music author may transfer his reproduction, translation, and adaptation right to a publisher. He or she may also decide to split his or her rights. I was talking about splitting of rights. Say there are 5 economic rights. I have decided to transfer 2 rights and retain the remaining 3 rights. So that has to be mentioned in the agreement properly. Transfer of copyright may also be for a period of time and for a certain territory. In respect of license, say, I'll give you an example of a book. Say, you've written a book, you have given in the copyright to a publisher. The publisher can decide that X in the state of Karnataka will be having the license to publish it in paperback edition, and the publisher may give the license to Y in the state of Gujarat to publish in a hardbound edition. You understanding? So in that case, see, the transfer of the copyright is based on territory. If there is no limitation in respect of the territory which you have mentioned, it will be understood that the transfer is in respect of the entire country. We'll come to that later. But you are not sure about the success of your work pan India. Will it be prudent enough to give a success for the entire country? So in that case, depending on the chance of commercial success, you should identify in which geographical area your work will be success. That is why you are licensing it. Why are you licensing the work? Because you want to commercially use the work. Why? Because the investment which you have made in creation of the work, you want to recoup the investment. That's why intellectual property rights are there. Until and unless you can recover the investment which you have made in creation of the work, why you should create the work. So that is why transfer is necessary. But at the time of drafting the agreement, you should be very mindful of the time, because if it is a license, it is of a limited transfer. Is it for 6 months? Is it for 1 year? Is it for 2 years? That has to be clearly mentioned in the document. And the geographical, the territory part also has to be mentioned very clearly. I'll come to that later. Now, this is transfer of copyright is serious business and should be entered into only after proper legal consultation. Right? That is where, because it is a complex document which contains different rights. So, also one thing to note is that an assignment is valid only when it is in writing. Now, is it because I am telling that? No. Section 19 of the Copyright Act mentions that. If you refer to Section 19, Clause 1 of the Copyright Act, it says that assignment, if it is in writing, then only it is valid. So, what is the implication? An oral assignment is invalid. Right. So this is the core provision of the Copyright Act, which talks about assignment of copyright. As I already told you, copyright in an existing work or the prospective owner of the copyright in a future work may assign to any person the copyright either wholly or partially. I hope I explained what you mean by wholly and what is partially. I also said that it can be in respect of an existing work or an prospective work owner in a future work, right? But only condition in case of a future work is that assignment will be complete when the work is actually done. So that's why next the provision says that no such assignment shall be applied to any medium or mode of exploitation of the work which did not exist. Sorry, it shows a typo. Which did not exist or was in not in commercial use at the time when the assignment was made. Now, what is the implication of this? There were a lot of disparity between different high courts about the mode of exploitation, means the means of communication. Say when the work was created, say maybe, for example, 30 years back, was there any use of internet at that point of time? Very minimal, almost. Say even if we're not say 30, say 50 years back, right? There was no use of internet at that point of time. So if I license a particular work, and I say that I am doing license only in respect of magnetic tape records. So you know what is VCR, video cassette recorders, those jumbo size players used to come. So if the license is only in respect of VCR, so does it automatically include internet also? That was a question. Some high courts of India said that no. If you are talking about transfer in the form of VCR, it would automatically include future modes of transfer, say internet today. But there are many high courts in India which said the opposite, said that if the license is in respect of in the form of VCR, it should be VCR, not internet. That's why to remove this confusion in 2012, the Copyright Act got amended, and that's where this provision was added. And the law now says no such assignment shall be applied to any medium or mode of exploitation of the work which did not exist or was not in commercial use at the time when the assignment was made. So if my license was in the form of VCR, it would stay in the form of VCR only and would not include internet. Until unless by agreement you agree. Now, one of the most important highlight of Section 18 of the Copyright Act is mandatory royalty sharing provision. Anyone familiar with what you mean by royalty sharing provision? All of you know what is royalty, right? So when there's a license, the consideration is known as royalty. Now, what is this mandatory royalty sharing provision? I'll read the provision and then come to the discussion. The author of the literary or musical work included in a cinematograph film shall not assign or waive the right to receive royalties to be shared on an equal basis with the assignee of the copyright for the utilization of such work in any form other than for the communication to the public of the work along with the cinematograph film in a cinema hall. Is it making any sense to you? That's because that's how we write law. There are how many sentences? 4 5 sentences in, you know, lines in one sentence. Is it making any sense to you? What do you mean by mandatory royalty sharing provision? Okay, let me explain. We have to go back to the situation before 2012 and then explain. Also, we have to understand that we have to compare with Hollywood and Bollywood. I do not know whether we can compare, but still, in respect of use of soundtracks in movie. If you see the movies which are produced in United States in Hollywood, uh, they just produce the movie. Songs are not part of it. Background music can be there, but if we refer to Indian movies, they are incomplete without soundtracks. Whether it is relevant or irrelevant, I'm not going into that person. I'm the least creative person, so I should not be talking about that. But you see that soundtracks are integral part of the cinematograph film. So, who is the owner of the cinematograph film? Copyright owner of the cinematograph film? The producer. So if there is a particular song to be included in the uh, movie, so who will be commissioning that particular song? The producer. But we saw that what does the law say? That the person who pays the commission becomes the copyright owner of it. So if the producer of a cinematograph film is commissioning, I hope understand commissioning, like hiring a lyricist and a composer to write the tune, to write the lyrics of the song or to compose the tune of the song. In that case, before 2012, the producer of the cinematograph film would get the right in the songs as well. So, in case of any future use of that sound recording, maybe by way of ringtones or any other forms, the lyricist and the composer was not getting any rights in that. So that is why there was a change brought in 2012 and said that in case of any future work of that song, along with the producer, the royalty has to be equally shared with the lyricist and the composer as well. Before 2012, the producer had no obligation to share the profit with lyricist and composer. Are you understanding? That's why it is known as mandatory royalty sharing provision. This is provided under section 18 of the Copyright Act. Are you really understanding what I'm telling? I hope so. This is because you know who advocated for this provision? I mean, who lobbied for this provision? Javed Akhtar lobbied for this provision because at that point of time he was the member of Rajya Sabha. So isn't it very ironic because he himself is a lyricist and a composer? That's why it is only literary or musical work. In no offense to Javed Akhtar, is a very reputed person, but this is how lobbying works. So himself being a lyricist and composer, he has advocated rights only in respect of lyrical work, literary works or musical works. But thanks to him, because of which now the producer of a cinematograph film has to share the royalty on an equal basis with the lyricist and the composer. Before 2012, this obligation was not there. Moving on, these are certain basic requirements when you are assigning the copyright. In other words, when you are selling your copyright. You understand that why the word sale is not there, but assignment and sale is almost equivalent. These requirements are provided under section 19 of the Copyright Act. The first requirement is that the assignment should be in writing, signed by the assigner or by his duly authorized agent. So it means that not only the owner, but an authorized agent can also assign the copyright. Specify the amount of royalty and any other consideration payable to the author or his legal heirs during the currency of the assignment. You know that any contract will be valid only when there is due consideration. So similarly, in an assignment agreement, there has to be consideration which is supposed to be paid. Shall identify such work and shall specify the rights assigned and the duration and the territorial extent. So I want you to note these are the specific requirements which has to be mentioned in the agreement. The first one is the type of work. Are you assigning the sound recording or musical work or literary work? What is the type of work you are transferring? The next is, what are the rights are you assigning? Are you transferring all the economic rights at one go, or are you transferring the reproduction rights? Are you transferring the distribution rights? Are you transferring the broadcasting rights? To specify that. And the duration. Usually, assignment is for life. You have to mention that. If it is for a limited duration, then it no longer remains an assignment, it becomes a license. You understand the difference? Right. And also the territorial extent. In what geographical area you're transferring it? Is it based on a particular taluk? Is it based on a particular district? Is it based on a particular region, the entire state, the entire country? You have to mention that, because the word used here is shall. You understand that? It's not a directory provision, it's a mandatory provision. So while drafting the agreement, you have to keep a check of this. If the assignee does not exercise the rights assigned within 1 year, such assignment shall be lapsed. So after the assignment, if the rights are not exercised within 1 year, the rights which is transferred by of assignment will not be taking place, will be lapsed. And if the period of assignment is not stated, it shall be deemed to be 5 years from the date of assignment. You understand that law is telling that be careful about the duration. If you are not mentioning the duration of the assignment within the contract, then it is assumed that the duration will be 5 years. And if it is of 5 years, will it be an assignment or a license? If the transfer is for 5 years, can we consider it as assignment or license? It would be license. So that is why if you have to be very careful about the duration which you are mentioning in the agreement. If the territorial extent of the assignment of the rights is not specified, it shall be presumed to extend within India. Right, so there are different kinds of license: exclusive license, non-exclusive license. Exclusive license means you are giving, say, a particular movie. You are giving the right only to Amazon Prime. These days, many movies are published in OTT platforms. So, say a particular theatrical rights is given only to Netflix, then it will be considered as an exclusive license. But you see that the same movie is available in different platforms. My one of the favorite movies is Saving Private Ryan. Yeah, I like war movies, of course. So, Saving Private Ryan is available in Amazon Prime. It is also available in Netflix. So, it's an example of a non-exclusive license. So, the producer of the movie has given license to Amazon Prime plus Netflix to uh, to communicate that particular movie. So that's why territorial the extent has to be mentioned. Otherwise, it would be presumed that it is for the entire India. Now coming to the second type of transfer, that is licensing of copyright. Please note that Section 30 of the Copyright Act talks about licensing of copyright. So the owner of the copyright in this is the text of Section 30. The owner of the copyright in any existing work of the prospective owner of the copyright in a future work may grant any interest in the right by licensing in writing by him or by his duly authorized agent. So, what is the lesson we are taking? Be it assignment or license, it has to be in writing. As we said, copyright is a negative right. That's why consent of the owner is required, and that's why there's requirement of permission to exploit the property in your consideration. It's a promise by the licensor not to sue the licensee. As I told you, that any unauthorized use of the copyrighted work without the consent amounts to infringement. That is why you need to take license when you are using. That is why downloading music from torrents is illegal. Why? Because it's not a licensed use. Right. So because copyright talks about exclusive right, it confers monopoly. The creator himself or herself many a times they're unable to utilize property to its fullest extent. That's how they're inviting or permitting others to utilize it. Just to give an example, from the perspective of trademark, say this famous chains like KFC, Subway. You see, there are different, franchisee of the same brand. Why franchise is given? Because the owner may not be in a position to fully exploit the commercial benefit of the trademark. That's why they go for franchising, merchandising, so that they allow others to use the trademark of KFC or Subway and use the commercial goodwill and reputation of the brand. Similarly, In case of copyright-based works, many times the owner of the work may not be in a position to use that particular work himself or herself. That's in that case. Why do people, give their premise on rent? Because they may be themselves are not occupying it. Similar logic is applicable here. So that's why they're permitting others to utilize it. The benefit of licensing is it allows you to fully realize the economic potential of a work. It helps in concentrating on one's core competencies. It helps you to find out, to see that whether it is new markets can be accessible. It helps in risk management. Many a time, assignment is not a good idea because in assignment, lump sum payment is made. You have to understand that you are not sure about the commercial success of a work. In that case, you want to try and test the commercial success of that particular work. In that case, license is a viable option. If you understand what I'm telling, based on the commercial success of the product in the market, maybe at a later point of time you can think about assignment or sale of the particular work. Um, this is the points of distinction between assignment and copyright. An assignment transfers an interest and deals with the copyright itself, but license does not grant copyright but only grants a right to do something. In case of assignment, the ownership or the title of the work is transferred. I hope you understand that. When your ownership of the entire work is transferred, barring moral rights cannot be transferred, but ownership is transferred. So when you're selling your two-wheelers, so the what happens, the title in respect of your two-wheelers get transferred to the new purchaser of it. So similarly, in case of an assignment, you are transferring the interest in the copyright, means the title in the copyright. But in case of license, you are not transferring the ownership. You are giving license or right to do something for a limited period of time. That's why it is said that assignment transfers title in the copyright, license permits doing something. Assignment is invested with title, you may reassign, but license is not personal and therefore not assignable. Say you have assigned the copyright, the purchaser of the copyright can again sell the copyright to another person. But in case of license, sub license is not allowed until and unless the contract is specifying that. Uh, See, how do you find out whether it's an assignment and contract? It's a little difficult to identify sometimes, but generally it is said that if the consideration was payment to the author of royalties or a share of profit instead of a sum of money paid down, the inference is that the copyright was not assigned but that a sole and exclusive license was conferred on the publishers. So you can identify that whether it's an assignment or license based on the modes of consideration. If it is a payment, one-time payment, or it's a lump sum payment, generally the presumption is that it is an assignment. But if the payment is based on royalty, or if the payment is made on the basis of installment, then what would be the presumption? That it is based on license, it is not an assignment. So if the payment is one-time lump sum payment, assumption is the transfer is assignment. If the payment is not on the basis of one-time payment but on the basis of the royalty, in that case the presumption is that the transfer is license. Right? That we need to be careful while you're drafting it. These are some of the licenses which are prevalent in the music industry. For example, mechanical license. What do you mean by mechanical license? The licensing of musical compositions for use in compact disc, record, tapes, and similar audio-only formats, which is known as mechanical license. So, when you buy a CD, I do not know whether you buy a CD. I'm sure none of you buy a CD. But even though, so when you are recording the audio-only format, for example, in MP3 format, right? So, if you are buying a digital copy of a sound recording, so the recording of the song in a digital version will be known as mechanical license. So this is the license which the record labels take from the producer of the cinematography. Right? So there is a song, and now they are giving the license to the record label. So that is what is known as mechanical license. The second is known as dramatic adaptation license. What is that? It's a permission that authorizes one to make a dramatization of a musical composition or more accurately its lyrics. This is the second type. The third type is known as performance license. This I'll explain in details. It is a permission that authorizes one to perform a work publicly. Publicly in the sense in respect of a commercial use. Even when a song is being played in a classroom, that is also publicly played. But that will not be considered as a case of copyright infringement, even though you are not taking license. I told you there is something called fair dealing. But otherwise, if in a public space, if there is a commercial, premise where the sound recording is being played, permission is required. There are certain exemptions also to the section 52. For example, if a sound recording is played in any religious place, right? For example, in a mosque, in a church, or in a temple, license is not required to be taken according to section 52. Moving on, there's something called synchronization license. This synchronization license is the right to record as a part of the soundtrack of the film. This is a license generally taken by the producer of the cinematograph film. Next, we have musical product license. I do not know whether you have observed that the famous movie in India, the Hindi movie that is Dhoom, right? All of you know that it's a very good movie, right? So it's the title track of that song became very popular. It becomes so popular that when a person is driving vehicle and if he's putting his vehicle in rear, in back gear, you can, it was a very annoying at that point of time. You see that everywhere it was there. You're going to a particular, in a marriage ceremony, that song will be played. If you're going for, any fair or exhibition, that song will be played. If you're putting your car in back here, the song is played. So why? That is why there is something called musical product license. So it is a form of permission that authorizes one to take mechanical reproductions of a musical composition in connection with the distribution of a commercial product, such as musical greeting cards, singing dolls, etc. Right? I have seen during my childhood days that this Doom Machale track was very popular. There were these toys whenever you push one button and in its highest possible pitch that song will be played. So that also requires license. It is known as musical product license. I couldn't think of a better example than that. Uh, while opening a greeting card, sometimes certain tunes are there, so that's why musical product license is there. The certain thing called print rights licensing. This license refers to the physical copy of the sheet music. Sheet music is the graphical music. So I guess my students also give the same expression when I say sheet music. Here we're talking about the graphical notation. That is what is known as sheet music that an artist has created. It is needed when someone prints a sheet music compilation. So I told you about the graphical notation. When it is printed and you want to use that, it requires a license. Theatrical license is very easily understandable, a form of written permission. Theatrical licenses are very common in the theatre industry. The license is required anytime a copyrighted work is performed on stage in front of an audience. Moving on, this is the entire scheme of the transfer of copyright as per Copyright Act. This is what we were discussing. Transfer of copyright basically takes two forms. Ma'am, I can take another. Right. So, basically, transfer of copyright takes two forms: assignment and license. Anyway. So you see that the basic modes of transfer of copyright is twofold: assignment and license. We talked about assignment already. We also talked about license, but license can be again further divided into voluntary and involuntary. Can you guess why I'm talking about voluntary or involuntary? Generally, license are voluntary. If I'm the owner, I will decide whether to license or not. But in the scheme of Copyright Act, there are certain situations where, against my desire, my wish, I have to give license. So that is why it is known as involuntary license. An involuntary license can be further divided into compulsory license and statutory license. Now, what is compulsory license? Compulsory license is provided under Section 31. I'll read the statutory provision. If at any time during the term of copyright in any work which has been published or performed in public, a complaint is made to the commercial court that the owner of the copyright in the work has refused to republish or allow the republication of the work, or has refused to allow the performance in public of the work, and by reason of such refusal the work is withheld from the public or has refused to allow communication to the public by broadcast of such work, or in the case of a sound recording, in such sound recording, the commercial code may grant a compulsory license. It's a long provision. What it is trying to say is that, I'll just give an example of a compulsory license. Say there is a FM station which is playing sound recordings. I hope you understand what is an FM channel, right? So when they are playing sound recordings, they would require license, isn't it? Why? Because it is a communication of the work to the public. So from whom they will take the permission? Who is the owner of the sound recording? The producer of the sound recording, the record label. Many a time there are lots of disputes between the royalty rates. So there is a way of determining the royalty, that is, they call it needle per hour basis. There is a particular way of calculation of licensing fees. So if there is a disagreement between the recording label owner and the FM station owner, the FM station owner can ask for compulsory license under section 41. So if there is a disagreement in respect of royalty, an application for which can be called for compulsory license. That's why I said that it is a type of involuntary license. Say as an owner, I will decide whether to license or not. But if the other party is not okay with the royalty fee, in that case they can make a complaint to the commercial court, and if the conditions are satisfied, they can ask for a compulsory license. The second type of involuntary license is statutory license. I think, sir, you were talking about cover versions. That there are different versions of the same song,
Yes.
right? So that is known as version recordings, and Section 31C of the Copyright Act deals with it, right? So what we know that in case of original sound recording, there is a original composition and but with the permission from the composer lyrics, sometimes you create new sound recording based on an existing song,
Yes.
right? Where what happens is the tune remains the same,
Tune is.
the word remains the same, the singer becomes different. That is what is known as version recordings in popular, uh, terminology. But the statutory word used is cover version. Section 31C talks about how you need to take a statutory license for cover version. So, what is a cover version? It is a sound recording made of an already published song by using another voice or voices and with different musicians and narrators. So, to answer your question, sir, you need to take a cover version. But it would be a very interesting study if you look into YouTube, that how many singers actually take license under 31C before they publish cover versions,
Yes.
right? So version recording is neither copying nor reproduction of original recording. That's why licensing is required. Prior notice of intention to make cover version is required. Copies of all covers labels with the covers has to be provided, and of course it's subject to payment of royalties. These are some examples of cover versions. In 2007, this particular song got released for in respect to the movie Om Shanti Om. In 2021, the cover version of the same song was published by a band called Masala Papri. Similarly, this song called Zinda from the movie Bhag Milka Bhag, which was published in May 2013. The cover version of the song was published by Pineapple Express in May 2018 because, as per the provision, Section 31C, a cover can be made only after 5 years from the publication of the original song, not before that. So you see that the original composition was published in 2013. The cover version was made in 2018. This was published in 2007, but it was published in 2021. 80% of the cases which I've observed, cover versions are not taken. So it's a case of violation. Um, there's also section 31D where it says that any broadcasting organization desirous of communication to the public by way of a broadcast or by way of performance of a literary musical work and sound recording which has already been published may do so subject to the provisions of this section. I'm not going in details of the provision, just trying to talk about the objective of this provision. If a FM station wants to play a sound recording, they can take a statutory license under section 31D. Now, the difference between compulsory licensing and statutory licensing is, in case of compulsory licensing, the commercial court determine the licensing fee. In case of, and that happens based on the argument by both the sides. So both the owner and the proposed user appear before the commercial court, they negotiate what would be the license fee. But in case of statutory license, no such kind of negotiation happens. There's a tariff published by the owner. You pay the licensing fee and use the work. That is what is statutory licensing. I'll move on. Uh, when talking about public performance license, I talked about when talking about different kinds of license. I talked about public performance license, right? So public performance is where at a place where public is or can be present, at a place which is not open to public, but a substantial number of persons outside the normal circle of a family and close acquaintances are present, and it can be communicated by record. So there is no definition of public place under Copyright Act. But these are the places which are considered as public place. For example, hotels and resorts, restaurants, bars, airports, cinema halls, shops, offices, discotheques, cruise liners. So these are considered to be public places. These are some examples of public performance. They are very old instances, but good examples. Programs of music and gramophone records played at a factory using loudspeaker for the benefit of the worker was considered as a public space or place. The playing of records over loudspeaker more or less continuously in a record shop to increase the shop owner's profit was again considered to be a public performance. Playing music on a loudspeaker in a private room adjoining a public restaurant in such a manner that the music was audible to the public in the restaurant was again considered as public performance. Now, the next most important when you talk about public performance license is copyright society. Now, before we talk about copyright societies, I hope all of you know that why cooperative societies are formed. Cooperative societies are formed for the purpose of convenience. So that is why, because public performance license is a legal necessity under Copyright Act for playing music in any format in public place. So you see that if you are arranging an event and you are in that event you are playing sound recordings of four different record levels. So how many times you have to go and get a license? 4 times. But if there is a single window where you can pay the license fee and get a public performance license, in that case, you don't have to approach 4 times to record levels. That is why copyright societies are formed, right? The details are here. Minimum membership required for registration is 7. Ordinarily, only one society is registered to do business in respect to the same class of the work. Some of the examples of the registered copyright societies are Indian Singers Rights Association, that is ISRA. This is for performers' rights. IPR is for Indian Performing Rights Society Limited for literary works associated with musical works, and for sound recording, there is Recorded Music Performance Limited or RMPL. The purpose of having a copyright society is to issue licenses in respect of the rights administered by the society, to collect fees in pursuance of such fees, and to distribute such fees among owners of copyright after deduction of the administrative responses. To give example, this is the home page of the official website of Indian Singers Rights Association. So if you want to take any license in respect of performance rights, you have to approach ISRA. This is Indian Performing Rights Society. The director of IPRS now is again Jagadatta. So in order to take license for the musical works and the literary works, you have to approach them. And as far as the sound recording is concerned, you have to approach RMPL, that is Recorded Music Performance Limited. This is the official website of RMPL. Now, these are the different types of license that are issued by them. First of all, television license, which is applicable to shows which involve use of a sound recording. Telecom related license for ringtone, music messaging, and other telecom value added service. Radio license, internet license, events license, public performance license, which we already talked about. Now, while you are drafting a license agreement, please take a note. These are the key provisions. These are the provisions which should be there while you are drafting a licensing agreement. What should be there? There should be recitals. Recitals is about the details of the parties of the transfer. Secondly, if you are using any technical words, the definition should be contained there. what should be the duration of license, because license is temporary for a limited duration of time. Grant clause talks about the rights which were specifically transferred. The royalty clause talks about the amount of royalty. Then territorial extent, who will retain ownership, the rights and obligations or the credits and attribution. If there is a dispute, who will have the jurisdiction to resolve that dispute, and when the license will be terminated. So these are the major provisions or the mandatory provisions which you should keep in mind while you are drafting a licensing agreement. Now, there's something called cross licensing agreement. That is, it's a kind of a mutual transfer. It's a legal contract between two parties where each party grants the other the right to use their respective intellectual property. The purpose is to establish a balanced and reciprocal relationship, ensuring that both parties can utilize each other's IP without fear of litigation. To give an example, it happens mainly in respect of patent and trademark. Say Infosys and Wipro, right? So they are licensing each of their intellectual property to each other. In that case, they can enter into cross-licensing agreement, which is much more of a convenient type of transaction. It is beneficial in technology-related industries where multiple companies often hold patents that are relevant to one another's product or services. Lastly, the most important part of any licensing agreement is its determination of royalty. You understand that I say that if the payment is based on royalty, then only it's a licensing agreement. So, royalty sharing provision in a music licensing agreement outlines how the royalties earned from the licensed music will be distributed. It is crucial to ensure fair compensation for the use of the music, and to specify the terms under which the parties will share the revenue generated from the licensed use. And the most important part is the royalty percentage. How do you determine that? Now, this is where the tricky part comes. The agreement should specify the percentage of revenue that will be allocated as royalties. This percentage determines how much of the earnings from the license work will be paid to the licensor. Now, there are different factors that are taken into account while you determine the royalty of a particular licensing agreement. Now, one of the most straightforward methods is to agree on a percentage of the licenses revenue generated from the use of the licensed music. This could be a percentage of sales for physical or digital copies, streaming revenue, ticket sales, or any other applicable revenue form. Certain cases they agree to a flat fee also. The parties may opt for a flat fee arrangement where the license pays a fixed amount upfront for the right to use the music. The problem is, if you're not sure about the commercial success of the particular song, then flat fee is not a good option, right? In that case, if you go on a percentage of sales, then it would be much more convenient. And there's something called minimum guarantees. In certain situations, the licensee may offer a minimum guarantee, which is the predetermined amount that will be paid to the licensor, regardless of the actual revenue generated. Certain cases, there is a variation based on territory, depending on the scope of the license. Different royalty rates might apply to the different geographical territories, and the length of the licensing agreement can also impact royalty calculation. Say, if it is for 6 months, there will be a particular rates of royalty. If it is for 2 years, of course, longer term licenses may provide for different royalty rates or escalation over the time. So this is where I conclude my discussion. If you have any question, I can answer them. Thank you.
With respect to that infringers of using that local, so using that local language and creating this song and using that popular music,
That is an infringement.
that is
That's an
infringement.
infringement.
So,
Problem is enforcement of copyright law in our country is very minimal.
that is the problem.
That is one of the problems. My PhD thesis is precisely on that.
Yes, sir. So
Study
many songs I heard in rural areas, but they are using the music, popular music.
License should be taken because if it is a cover version, 31C. If it is an adaptation, then also license is required to be taken under Section 14.
Yes, sir. The finding the infringers is very difficult.
Very difficult. That's why the level of enforcement of copyright is very minimal. Especially in the internet, it is next to impossible.
Yes, sir.
So that's why I started the discussion with the public good aspect of intellectual property. Why it is difficult to protect intellectual property, why it is difficult to enforce the laws. The problem in our country is that we have good statutory protection.
Yes, sir.
Copyright Act of 1957 is one of the most progressive copyright law of the world in terms of its scope and ambit. But the problem has remained is its awareness of the law, first of all,
Awareness.
and I could see the real picture to what extent people care about copyright law. I mean, that's a reality, and even the enforcement agencies are not well trained. There are cyber sales in every police stations which are vigilant about cyber frauds. But unfortunately, not much attention is given or training is given to the law enforcement enforcers so that they can keep a track of pirated copies.
Yes, sir.
My personal experience while doing my PhD research work, I have seen a police officer in uniform buying a pirated music song recording from a pirated shop which is within the 1 kilometer radius of the police station. So that is the reality of the enforcement in our country. The laws are there in place, but its observation is something which
Yes,
is
sir.
not.
Enforcement is poor.
Yes.
Thank you so much, sir.
Yeah. I think there was one another question. Yes.
So generally, so there's a generally there's a indemnification clause in agreements, right? So will this apply in music?
Absolutely. Indemnification warranties clause are also there in the music licensing.
So how will we ascertain the damages, sir? Like, will there be a lump sum amount in that clause, or
Here, it primarily depends on the negotiation of the parties. See, Copyright Act, Section 18, 19, they do not talk about indemnification, warranties, etc. So it is based on the respective negotiation between the parties. The Copyright Act merely lays down the skeleton. That while you are transferring the copyright, these are the basic things which has to be satisfied. Everything else is depending on the negotiation and how do you can bargain with the other party. So there is no fixed rule specified by the Copyright Act or rules as to what should be the nature of indemnification, warranties, etc. That is predominantly decided by the respective parties. Right? But you are correct. Those clauses are I have not mentioned here because if you take a sample agreement, it is a part of any music licensing agreement. But the conditions are determined by the respective parties.
sir, when it, sir, for a minute, can I request you to go to the previous slides where key provisions of licensing agreement. Sir, coming to dispute resolution, lately with so much of homework that is to be done regarding the flat fee, royalties,
That's why it is a complex
how
document.
to determine that. How would
Also, when you talk about dispute resolution, many a time the parties opt for ADR. So, and the present trend is they do not go to the court; they resort either for arbitration, mediation, or conciliation. So, again, as far as this governing law and jurisdiction is concerned, this has to be decided by the parties. As I say, that in case of assignment and licensing, it is the Indian Contract Act which has to be consulted along with Copyright Act, all the relevant laws.
so my question is if the dispute clause that however they draft the clause, will it be specific to royalties? One
That the
clause,
parties have to
or
agree. The
any-
act is
any-
silent on it.
any
Anything.
dispute, any
Any
dispute.
dispute in respect of royalty sharing, in respect of the jurisdiction, that which court will look into the dispute. Many a times, most of the times, the Delhi High Court is given the jurisdiction to resolve the dispute. So that is why I'm telling that it is left to the parties. As he was telling, indemnification left to the parties. Dispute resolution, governing law jurisdiction, that is the parties to decide that. If you read section 18 and 19, they're totally silent on all this because that is not the purpose of Copyright Act. The purpose of Copyright Act is to say what works are protected, when it is protected, how you transfer, and if someone is using your right without you permission, what would be the consequences. As far as the drafting of contract part is concerned, it is predominantly guided by Indian Contract Act or the necessary rules and regulations. Even as far as the capacities of the parties to enter into a contract, it would be guided by the provisions of Indian Contract Act. Thank you, sir.
So my question is, what are the mandatory contractual clauses?
Mandatory
Contractual.
clauses. There is no specific mandatory clauses prescribed by the Act. But these are the clauses which I have observed in most of the agreements. This is their mandatory clauses. If you talk about the most important clauses, I consider duration of license, grant clause, the royalty clause, territorial extent. These are the most important because most of the disputes occur in respect of these items. Maybe there will be dispute in respect of which territory it was licensed, what are the rights. As I was said, that if there is an ambiguity as to what are the specific rights that are transferred. So these are the clauses which are often subject matter of dispute. But all depends on the negotiation between the parties. If any terms and conditions they are okay to include it, they can do that. That's why if you see Trademarks Act in their Schedule 1 lays down the different forms, but in Copyright Act, if you see the annexure, the form for registration is there, but there is no template given for license or assignment. That is because the Act has given the decision to the parties to agree on how they want to enter into a contract. So that is why the requirements of Contract Act will be applicable here.
Okay, sir. My another question is, on related to the cover versions, is the original author of the song had any right on the copy which created with another?
No, because it is a licensed version. So it is a different expression. So in that case, the right is limited only to the creator of the cover version. The original composer will not have a right over it.
If they made any alterations or in the
If alterations are made, then permission has to be taken. So if you see in cover version, the same tune is made. So there's a difference between remix. There's a remix cover version and alterations or adaptations. The remix is an infringement of copyright generally because what you are doing is, in case of remix, you are using the same sound recording. You are either increasing the tempo of the song or decreasing the tempo of the song. If you go to YouTube today, you see the lo-fi version of the songs or the reverb version of the songs. These are nothing but the same recordings, but you are just interfering with the tempo and speed of the song. So it is an infringement of copyright because you're using the sound recording. But in case of cover version, a different singer is singing that song, but still you need to take a license. It's not a reproduction. But if it is an adaptation, in that case, it is a separate reproduction. So you need to take permission, otherwise it would be an infringement. Also, you may have a question on parody. Parody is also a type of interference. In India, parody is not a case of fair dealing. In the United States, it is. So in India, parody is as good as infringement of copyright.
sir, we have the 5 years time duration
cover
not to
version.
create other cover versions. What was the legal process? What are the legal?
I have to talk to the legislators for that. I am personally not aware of that. A certain cooling period is always there. If you look into Patents Act also, if you look to Section 84 of the Indian Patents Act, an application for compulsory licensing can be made only after 3 years of the grant of patent. So these 3 years are given to the proprietor or the owner to commercially use the song. After that, they may give license. So that's why maybe 5 years of that. It's not recorded anywhere.
Thank you, sir.
Sir, the scope of mandatory royalty sharing provision, wherein copyright is a bundle of rights, in a sense, in a way, a bundle of obligation too. So, wherein
Mandatory royalty sharing provision is only in respect of two type of works:
yes, sir, literally,
literary work and musical works.
yes. So, wherein a producer, in a sense, when I'm taking a song for a performance, I will also have to take the permission of the
ISRA also, Indian Singers' Rights
yes, a
Association.
composer and a lyricist in a sense. So, why is a mandatory royalty provision?
If you refer to Section 33, Clause 3, it says that for one type of work there can be only one copyright society.
Yes, yes.
So for sound recording, you have to talk to you have to take permission from one copyright society. So for performers, you have to take permission from different things. But for mandatory royalty sharing provision, that is applicable only where the song is used not in a theatrical performance. So, but because the producer has produced the film to exhibit in a theater, so that's why as long as the song is played as a part of the movie in a theater, there is no requirement of mandatory royalty sharing provision clauses. But if the song is used otherwise than in theater, say by way of ringtone, by way of ringback tone, or in any other exhibition the song is being played other than theater, then the question of mandatory royalty sharing.
It was not recognized before 2000.
Yes, it was not recognized, and there were lots of complaints filed. I mean, not officially filed, but lots of dissatisfaction expressed by the singers community. There have been instances that many singers refuse to take. We have this film fair awards, which anyways no one cares, but still they refuse to take those awards because all the rights and the credits were given to the producer, but not to the lyricist and the composer. It was because of the lobbying done by Javed Akhtar, because she was the member of parliament in Rajya Sabha. So Javed Akhtar lobbied this law and he got it passed. So that is why from 2012 onwards we have the mandatory royalty sharing provision.
Thank you, sir.
There you get to go home, I guess. Yeah. Thank you.
Good afternoon to one and all present here. It is with great pleasure and gratitude that I stand before you to deliver this vote of thanks on behalf of KLE Law College, Bangalore. I would like to extend a heartfelt appreciation to each and every one of you for gracing us with your presence in making this event truly special. First and foremost, our deepest thanks goes to our distinguished guests and speakers whose insightful thoughts and valuable expertise have enlightened us throughout this gathering. Your presence here is not only inspired us but also enriched our knowledge and understanding in various domains. A special word of appreciation is due to our guest of honor, Dr. AVISHEK Chakraborty, whose gracious presence has added a touch of eminence to this occasion. We deeply honored and gratefully for the valuable time and spared to be us today, sir. I request Mantesh sir to present the sampling to a guest of honor.
फोन कुट रही सर फोन कुट रही
Thank you, sir. I also thank our event coordinator, Mrs. Rashmi R. And in absence, I thank IQAC coordinator, Dr. Manoj Kumar, and Vice Principal Ma'am, Dr. Anita MJ, and our beloved Sir, Dr. JM Mallikarjuna. Our sincere thanks go out to all the participants and attendees. Your active participation and enthusiastic engagement have contributed to success to this event. It is your presence that made this gathering a vibrant and memorable one. We cannot forget the effort of our dedicated voluntary and staffs who have worked tirelessly behind the scene, and their hard work, commitments, and attention to detail have been crucial in ensuring a smooth and senseless event. So, in the end, I just thank you once again and have a wonderful day.
ಜಿ ಪೇ ಮಾಡ್ಬಿಟ್ನಲ್ಲ ಸರ್